Hi, this is Lauren Kim here at NFP. Our claim journal this quarter reviews many key legal developments from the first months of 2022. I want to highlight several of those for you now. The SEC announced proposed new rules relating to climate disclosures and cybersecurity. The much anticipated climate rules would require registrants to provide certain climate-related information in their registration statements and annual reports, including information about climate-related financial risks and climate-related financial metrics. On the cybersecurity side, the SEC also proposed new rules that would require public companies to report cybersecurity incidents within 4 days after they determine such a breach is material. The proposal would also require companies to disclose more information about prior incidents and describe their risk management strategies in greater detail. Both of these proposed new rules further the increased regulatory scrutiny we've seen out of the Biden administration, and definitely something all companies should be paying attention to. In employment news, Congress recently passed a bill that invalidates pre-dispute arbitration agreements regarding sexual harassment or sexual assault claims. Employees who were previously subject to mandatory arbitration agreements may now pursue those claims directly in court if they so choose. The legislation takes effect immediately and nullifies any existing pre-dispute arbitration agreement. This is pretty big news, and our EPL team will have a more detailed article out on this issue shortly. Financial institutions should take heed. The SEC is conducting multiple investigations of record preservation practices, and based on prior penalties, the consequences could be pretty severe. The first of these investigations recently wrapped against JPMorgan Chase, and it resulted in a $200 million fine regarding JPMorgan Chase's employees' use of unapproved email, text, and WhatsApp to discuss business, and JPMorgan's failure to preserve those conversations. It has also now resulted in a shareholder derivative action filed against JPMorgan on March 10, 2022. Several other large financial institutions have recently disclosed that they are also responding to similar federal investigations regarding their employees' use of unapproved messaging channels to discuss business. The Supreme Court also issued its opinion in Hughes versus Northwestern this past quarter, which impacts fiduciary liability. Although the ruling was not as expansive as some may have hoped, it did clarify that the determination whether a fiduciary breached their ERISA duties requires a context-specific inquiry of the fiduciary's continuing duty. It also recognizes that there's a range of reasonable judgments a fiduciary may make based on their expertise and experience. Finally, we have several interesting coverage cases highlighted in this quarter's journal. Not that I'm biased, but perhaps my favorite case of the whole journal quotes a very famous Sesame Street song in examining the architecture of language. So for all you coverage nerds out there, hopefully you find that one interesting. I certainly did. We look forward to continuing to report on these important legal trends and the impact they have for our clients.